Good morning, Alan Powell here. I'm the founder of the British Distillers Alliance and the Honorary Representative for the UK Warehousing Association. I've been in those roles several years, formerly with HMRC Policy between 1988 and 1998, where I worked in a number of alcohol production, holding movement and other core regimes. We're covering today the general ownership of goods in warehouse and the transfer of title of goods in warehouse, the obligation of the warehouse keeper, the seller and the buyer. With regard to the holding and movement of excise goods, and this is an important one to talk about, I want to look at what it is about holding and moving excise goods and the warehousing of excise goods and what's required of a warehouse keeper, owners and sellers of goods to comply with the law. Now, in order that third-party warehouse keepers can keep track of the owners and changes of ownership of goods in their warehouse, HMRC states in Notice 197 at paragraph 8.2, before making any sale, you as the current owner of the goods should check any purchaser's registration and inform the warehouse keeper that the goods are to be sold. And that's it. That's all required. In Notice 196 paragraph 3.34 under stock marking and control, and it includes a stock account must show the following details. Bullet point, the owner of the goods. That's it. You must make sure that your stock records accurately record any change of ownership. And that's reasonable. The warehouse keeper must know what's in the warehouse and must be informed of it. But that's as far as it goes. There is no further information or prescription or obligation on behalf of the warehouse keeper, the buyer or the seller. There is reference to, in the industry, to a delivery order. And the delivery order is a curious thing because really it's a tradition that the law ditched some time ago. And we look at what the law did say and where the notion or the concept or the convention of the delivery order came up is section 32 of the Alcoholic Duties Act 1979, ALDA, A-L-D-A. And section 32 of ALDA headed Restriction on transfer of British spirits in warehouse, stated under subparagraph 2. Spirits manufactured in the United Kingdom chargeable with duty which has not been paid, which are in any warehouse other than a distiller's warehouse, shall not be transferred into the name of a purchaser until the purchaser produces to the officer in charge of the warehouse a written order for the delivery of the spirits signed by the person in whose name they are warehoused and countersigned by the occupier of the warehouse or servant of his acting for him at the warehouse. Now you can hear that's an archaic provision, and that was actually carried over from the, I'll reach over to the Alcoholic Duties Act 1979. This is the original version. It was carried over from the 1952 Customs and Excise Act, section 110, which is probably, that's an Elizabethan statutory instrument, probably carried over from Victorian times. It's very ancient. That provision for the delivery order was repealed by Parliament in 2006. And bear in mind, the delivery order was to be produced to the officer at the warehouse. It's not to be produced to the warehouse keeper. It's the officer of Customs and Excise know what had happened. And in those days, HMCE as was, had officers fixed at warehouses, sometimes teams of officers, and they controlled the warehouse. They did the work of the warehouse keeper. When those officers were taken out following the warehousing reviews in the mid-80s, officers were taken out of warehouses. So the delivery order to the officer had absolutely no function. And it was removed with a whole swathe of archaic requirements. The delivery order was just one of very, very many provisions that were revoked, repealed by the Finance Act 2006, primarily section 5. And the heading of that section says, repeal of provisions of the Alcoholic Duties Act 1979 of no practical utility. And it wasn't just the delivery order that was ditched. It included many things that I'd worked in the department to remove as being not practical, of no purpose. This is why, in particular, and more recently, one sees problems with casks of goods sold in excise warehouse, potentially to investors. Because if an investor or an individual wants to buy a cask of spirits or brandy or whatever in warehouse, they have to be registered if they have a UK footprint, if they have a business address or are domiciled in the UK. And that means if you're a revenue trader for the purposes of that law, you have to go through this extremely onerous process. And what that's led to is brokers and warehouse keepers themselves, distillers selling new make and futures, wanting to sell to investors and coming up with a process that avoids the investor having to go through the WAUGA process, whereby a WAUGA registered person or broker can own the goods and has the ownership rights, but the beneficial rights in trust, or a concept called bailment, are owned by the actual owners of the goods who've got a contract and own the goods. And that contractual arrangement is what's behind it. But the issue of owning goods in trust and bailment is, it seems to me, a way that investors do not have to go through the pain of WAUGA, and has actually been confirmed by QC's opinion that I've seen. To be registered as an owner of goods in warehouse under WAUGA is a very draconian, difficult process. Customs ask you, the applicant, a lot of questions, some of which are actually irrational and difficult to justify why they would ask them. And they will ask for due diligence of the supply chains and risk of fraud and all sorts of things that actually aren't relevant to the cask sitting in a warehouse. But the applicant has to go through this process, and it is frankly baffling to them and intimidating to them. In order that investors can either for commercial reasons or for love of the product, or as founders reserve for a new distillery setting up a new make for futures, a process has been developed where such brokers, warehouse keepers, distillers become registered to own goods in warehouse and buy goods in warehouse, and act as the intermediate between the warehouse keeper and the beneficial owner who is contracted to own the goods. And it's a concept of trust and bailment, which I'd never encountered until I was given a QC's opinion on it and looked at it. And commercial things, these aren't excise matters, these are commercial matters and sale of goods issues, which effectively do look like a layer between the purchaser and the warehouse keeper, but in fact are consistent with underlying law. If WAUGA didn't exist, then the broker could simply arrange for the sale to the owner, to the purchaser, from the warehouse keeper, as they do for wine, as they would do for other fermented products, as oil traders do. It's just the curiosity of spirits sitting in cask is required to have this WAUGA ownership. But the beneficial owner is the owner, and the contractual terms between the seller and the buyer are the ones that commercially are the important factors. Now, I've covered one of the issues, one of the problems that one experiences, and I get this referred to me a lot about WAUGA registration. And I will make the point that WAUGA was actually unwarranted, and I will argue that it had no legitimacy, no need, and as legislation it is disproportionate. The warehouse keeper has to know what those goods are, has to know who owns the goods, and there's a very strong compliance regime operated by HMRC that should ensure that it stays that way. In terms of cask ownership, there is even less risk of alcohol duty fraud than possibly could be imagined. There may be commercial fraud, that's possible, but that could happen in wine, which is not covered by WAUGA. So what we're looking at is fairly redundant legislation, which, like the delivery order and loads of other matters of no practical utility, I believe should be repealed.